Hello, I'm Joseph Botelho of the Botelho Law Group, and in this video we are going over our series on Massachusetts landlord training. More specifically, in this module we're going over record keeping, keeping a paper trail, and keeping an electronic trail, and how this will save your business. Stay tuned. So you're a landlord in the Commonwealth of Massachusetts and want to run your income rental property business to residential tenants the best that you can. And what does this mean? Not what you might think. You might think it means keeping a place clean, making the tenants happy, and running a tight ship. That sounds all good, and that is required in Massachusetts to keep tenants happy. But what's more important is court. Because it's not if you're going to evict a tenant, it's when you're going to be evicting a tenant. It's not if you're going to be sued by one of your tenants, it's when you're going to be sued by one of your tenants. So in this part of our training series on record keeping, we are going to go over why it is critical for you to maintain a proper records and electronic paper trail. So both paper and electronic, I highly recommend using both. If you don't, I would suggest using electronic over paper. Both is better, but if you have to choose one or the other in this day and age, I would have to say electronic's better. Also, when you're maintaining records, be it paper or electronic, you want to maintain them in a way that you're not going to lose them, and in the future you're going to be able to find them as easily as possible. So the way to do this is you want to maintain records per property, meaning that if you have number of properties, each property address should have its own file system. So let's say you have a property address of 10 Main Street. Okay, 10 Main Street might have 3 units in it. So you're going to have one file just for 10 Main Street, and then 3 files inside of that for each individual unit. Now, on top of that, each individual unit, you're going to want to break that down and have specific files for each individual tenant. So remember, property address, unit number, tenants. Do this for every property you have. You can do this in a paper filing system with a filing cabinet. You can do this with digital software, or the simplest way to do it is get yourself a scanner and get yourself a dedicated email address from one of the free companies, you know, either your Gmails, your Yahoos, your Hotmails. Use one of the big name companies, something that's still going to be around, because this is also going to be used as your document storage. Considering what Gmail offers, I'm not paid by Gmail to say this, but their document storage abilities and software and all the apps that they have, I would just use a Gmail account and get your tenants used to speaking to you, corresponding, doing everything through email. Now, you might think, well, I have an email account now and it's a bloody mess. Well, remember what we described in how to set up a filing cabinet in your office for your rental properties? You can do the same thing with an email account, plus it's free. You just, in the left-hand corner of all the major, on the left-hand side of all the major emails, accounts, there's your section for your folders. What you want to do for every property you own, the actual property address, let's say, we're going to call this one 10 Main Street. So 10 Main Street, you would have one folder just for 10 Main Street. Then in 10 Main Street, you want to put subfolders for every unit number. And then further subfolders in every unit number for the actual tenants. So you want to break it down by property address, then after property address has to be unit number, after unit number it's tenants. Remember that lawsuits that pertain to rental properties generally have a statute of limitations of 3 years, such as personal injury and other monetary like breach of contracts, things of this nature are for 3 years, or 6 years pertaining to certain breach of contracts, and also if there's a debt owed. So the magic number here are 3 and 6. But since 6 is larger than 3, we're just going to focus on 6. Even though many statute of limitations will run after 3, just focus on 6 years. Why is this important? Because you need to maintain your records for that long. It's going to be very clear as we go on. But if you have any correspondence for a particular tenant, what you want to do is take your scanner, scan it in a PDF format, and file it away in your email account and put it in the folder that corresponds to that tenant. It's very simple. Make an email, upload the documents to that email, email yourself that email, and in the where the text goes in the email, just describe why you're saving this and why it's important. So you get to write notes on the documents you're putting in. So if you're scanning hard documents, you do not want to mark the documents. We'll go over that in a moment. You just want to scan them in the way they are executed, and then in the actual area where you get to put in text in email, just describe why you're saving it. What's the importance of this document? When did you receive it? Who did you receive it from? What is it about? You want to put that in, and now you've got your email account with all of your subfolders that will have emails that are in there by date, so you can easily see the entire tenancy of a tenant from beginning to end, meaning that everything that happened in the beginning, such as your lease or anything to do with a security deposit, last month's rent, any of those accounting, keep all those records, scan them in, send them to yourself, put them in the proper folder for that particular tenant. That way, if you ever have to evict them, or you have any type of lawsuit from them, or you have to deal with them on any level, you're going to look for the lease. That should be the very first thing, if the very first thing may be their application. But you're not going to keep every application in a separate folder for every tenant, prospective tenant. It is important to keep a copy of every application. Make a separate folder just for applications for tenants you denied. And you'll want to break those down by years, depending on how many properties you have. If you have a lot of properties, you might want to break it down by month or even week. I don't know how many properties you have. Whatever works for you. You do not want any document pertaining to your rental properties to disappear. You want to scan it in and have an electronic copy of it. And if you're not into the internet, not into using computers, not into using scanners, you can use a filing cabinet. I highly don't suggest this, because if you had a fire, if there was water damage, there's a million things that can happen. Or someone could steal the documents. There's a million things that could happen that would choose you to not choose a filing system such as a filing cabinet in actual paper. Also, with emails, you can have this set up in 2 different email accounts and have duplicates of everything. It's extremely easy. It's not twice the work, because instead of sending an email to yourself at one email address, just type in another email address and have duplicates that way. Also, it's very important when maintaining records or correspondence that they stay clean. This is most important when you're talking about documentations, especially If it has to do with from a municipality, from a police department, from the Board of Health, from City Hall, from any government institution, you want to keep those documents pristine. Do not write on them. Do not mark them. Do not highlight on them. If you want to do that, instead of getting a scanner, get yourself one of those multifunction printers. That's a scanner and a printer. You want to mark up a document? Make a copy of it, then write all over it. Make sure you keep a digital copy of every original document, because as we'll be explaining, that what you're going to be doing is not only good record keeping, this is important for every business person, but you're preparing yourself for the eventual evictions, and you're preparing yourself for the eventual lawsuits that you will be facing. So make sure you do not mark any of your original documents. Save them before you mark them. Never mark an actual original document. If you have to write on one, make sure that you make a photocopy, write all over that. Never mark up an original document ever. Period. End of story. Also, it's also important to keep an accurate rent ledger. Now, the rent ledger should include when the rent was received, the check number you were paid by, and the name of the person who wrote you the check, and even who gave you the check. These might not seem important at the time, but in the future, in an eviction or in a lawsuit against you, you're going to wish you did this. It takes very little time. Your accountant will love you for it. Your attorney is going to love you for it. And this is the best business practice. This is the way it's done. You wanted to be involved in real estate, you wanted to be a business person, you need to do it right, or you're going to pay a very hefty price in the future when you're either in an eviction or a lawsuit and you can't come up with this documentation. Because when it comes to court, if you don't have documentary evidence that you can provide to the judge to demonstrate that your side is correct, it's going to be up to who's the better liar. I see many landlords go to court, they don't have a single document on them, and they're just going to go in front of the judge and they're just going to say their story, and it sounds so good because they've told all of their families this story a million times. Who couldn't believe them? Well, that's because they're not saying it with the tenant right there, saying their version of the story. They're going to be crying. They're going to talk about their disabled husband, their disabled child, how this, that, and the other thing happened to them. Woe with me. And you know what? The judge in Massachusetts is going to pick the tenant over you. Why? Because you can't prove anything, because you never kept any good records. I cannot stress this enough. You need to keep good records. I know we've already had a video on this, but security deposits, last month's rent, please look in the description below. We'll have other we'll have links to our other modules on this Massachusetts Landlord Training session. One of them is about security deposits and collecting last month's rent. I went into great detail on what to do and how to keep those records, but it's important enough to say again in another video. Security deposits and last month's rent is one of the ways that most landlords get financially screwed. Just saying, just letting you know. And the damages for these are triple damages, or what we call in Massachusetts treble damages. And essentially, most landlords will get this at least once if they break the rules pertaining to security deposits and last month's rent. Also, all communication between a tenant should be in written format. That meaning if one of your tenants has done something and you want to tell them, let's say they broke the lease, broke the rental agreement, violated some of the provisions, you want to write them a letter, you want to send it certified mail, you want to scan the certified mail and the letter, save that in your emails or your electronic backup system, whatever it is you're using. I like the email thing because it's cheap and it's easy. and it's there forever. So whenever you have a communication with a client, let's say it's over the phone, send an email to the client right afterwards. Do not wait, because you're going to forget things. Type out an email explaining exactly what was said in it, what you said to the tenant, what the tenant said back, and give a summary and conclusion. And then send it to the tenant, CC it back to yourself. If the tenant doesn't respond to that email and saying, no, this is not true, this is not what we said, you've got proof right there that they're admitting that at the time. They're not going to think about it when they're reading your email and not replying to it or not refuting some of the comments, but that's what they're doing by not replying to it. And if they do reply, then at least you have a copy of their reply. At least this way, when you go to court, they can't lie. They're going to try to lie, but now you can bring this piece of evidence out and demonstrate it. And if they weren't smart enough to ask for discovery in the eviction process, they're not even going to know you're going to be providing that to the judge. So this is going to be one of those aha moments that you see in on the movies and stuff, when a lawyer catches someone in the middle of something. Yeah, oh my God, I can't believe I just lied to the judge, and now there's proof that I lied. These are the things that lawyers live for. Please be kind to your lawyer. Give us the evidence we need. Okay. Also, like stated, if the tenant violates the lease rental agreement, you want to send that to them. Certified mail, type out a letter, scan the certified mail, scan the letter, and then send a copy of the letter to them via email. I would wait at least a few days so they actually have the original letter, then give it to them, or they might never actually pick up the certified letter. So whenever you communicate with your tenant, do it by email. Or if you talk to them over the phone, or God forbid text messaging, you reiterate that in an email, send it to the tenant, send it to yourself. Your lawyer will love you for this. Great. Also, it is important that you get your clients, tenants, used to communicating with you in email. Do not let them text message you. It's too open of a form of communication. Unless it's an emergency, which if it's an emergency, they should be calling you or calling 911. There's no emergency in a text message. You shouldn't even be answering text messages like that. Do not become a slave to your phone. This is another practical reason for this. Do not let your tenants control you. Learn how to control your tenants. You got to get them used to a form of communication, and always keep that form in writing, or you're going to have to go through the trouble of actually rewriting that whole conversation. A lot of people are not going to understand the importance of this until it gets up on them and bites them right in the ass. Seriously, you have no idea until you're actually in the middle of an eviction that the tenant owes you $5,000, $6,000, $7,000, and you're up in front of the judge and the client starts lying, and you know they're lying, but you have no evidence to prove it. Then the judge believes the tenant, and the tenant probably brought other witnesses that are confirm the lies they're telling. This does happen. For instance, I had a case where one of the landlords that I represent, he was renting to a tenant. That tenant moved out, moved in with his girlfriend, returned the keys. He even left some of his stuff, but moved out most of his stuff. Broke up with the girlfriend, attempted to move back in. The landlord had already gone through the process of renting it to someone else. The other person wasn't in the apartment yet, but the simple fact was that tenant went to housing court and say that they were illegally evicted. And since the landlord had no proof of an eviction, since the tenant moved out on their own, but they had nothing in writing, not even a text message, which I'm telling you not to use, but there was nothing in writing demonstrating that the tenant had ever left the, what do you call it, left the property. Now the tenant gave him a call, and they discussed it, and then they met in person, and that's how they exchanged the keys. Great. Tenant's gone. Why do I have to worry? He's already given me the keys. I'm already going to rent it to someone else. Any tenant could just go to housing court and say you did an unlawful eviction or a self-help eviction, kick them out, change the locks, and rented it to someone else. And these are very difficult cases to disprove if you've got no evidence, because the judge is going to err on the side of caution, and they're going to believe the tenant. I had this situation happen. The landlord had no proof of anything, and we had to go right into the process and then start an eviction over, because there was actually no lease at the time. So we had to go through all of that. All the landlord would have had to do to save, I believe in the end it came out to about, if you consider how much the legal fees were, how much the place stayed empty for, and everything, it was over $6,000 this landlord faced. And the tenant left. He got the keys. He thought he was home free. And on top of it, good thing he didn't get sued by the other tenant that he rented the apartment to, because he did sign a lease agreement with that tenant. And because of that lease agreement, he could have got sued, because if you sign a lease agreement with an apartment that's not open and that person can get in, you're going to get in trouble for that. You can get sued for that. So I could seriously go on day after day giving you examples of how many things I've seen in the over 20 years I've been handling eviction laws, on how things would have went great for the landlord, how they simply had documentary evidence and kept a good paper trail for me to use as evidence in court. So, in closing, make sure everything pertaining to your property, the units in the property, and the tenants in those units, regardless what documentation it is, make sure you're saving it. I prefer using email. Also, I personally, when I used to manage 21 apartments buildings for my family, I owned six units myself, 2 buildings. I always also kept a backup SSD drive, one of those solid state drives, so it's not constantly connected to your computer. I kept the information on my computer, saved it on a solid state or just an external hard drive. I also use the cloud, but I also used email. It's not going to take that much time to use all of these. Best practices would be to store the stuff in 5 different locations, 6 if you can. It might sound redundant, but once you've created the file, it's very easy to put it in all 6 places. So it's not actually much more work to be redundant. But in this world, considering how many different ways we can electronically lose information, or you can lose paper information, have redundant systems in place. Also, as with all of our landlord training sessions, there'll be links in the description below. Visit all of them. The links will bring you to the blogs on our websites, which also have the videos from YouTube posted right in the actual blogs, but the blogs are much more extensive, and some of the blogs actually have downloads that you can see as examples for the documents that we're discussing. And in the future, I'll keep updating these, and I'll keep creating more documents that you'll be able to use for free. So please go in the description below, check out the links, and keep checking back, because we will continue to add more content. Before, this was stuff that I only made available to my clients. Now we're making it available to the world, and hopefully that'll make you my client. Thanks. Great. Love that. Okay, this is attorney Joseph Botelho from the Botelho Law Group with our training series for Massachusetts landlords. You have a great day. If you enjoyed this video, please press the like button and subscribe to our channel. Also, click the notification bell to get future videos that we'll be putting out. And please share our content on social media.
you.